Friends, ladies and gentlemen, good afternoon. I'm so happy and honored to welcome all of you to the Centennial celebration of the UP College of Law. To many of you, I'm sure this is a homecoming. The aftermath of the People Power in 1986 was not easy. It was a period of political tension and economic distress. It was, however, the most appropriate time to implement political and socio-economic reforms. To do exactly this, radical changes have to be done to the 1973 Constitution. The Aquino government did more than that. It abandoned the 1973 Constitution altogether, and the 1987 Constitution was born. The 1987 Constitution is a bastion of civilian supremacy. It also championed the evolution of power and public accountability. Understandably, the President's extraordinary powers were narrowed and restricted. The powers of the Judiciary were expanded, and a Human Rights Commission was created. Indeed, the 1987 Constitution was a reaction to the political and economic conditions during the martial law years. This afternoon, we shall look back to history through the eyes of no less than one of the chief legal advisors of then-President Marcos. I am referring to then Solicitor General Estelito Mendoza. We are privileged to have him this afternoon. Here in the UP College of Law, we call him as the lawyer's lawyer. The great Estelito Mendoza graduated cum laude from our college. He belongs to the legendary class of 1952. He obtained his Master of Laws from Harvard University and joined the faculty of our college. As a law professor, he is one of the most revered who taught almost every branch of the law. He was a legislator when he was elected member of the Interim Batasang Pambansa and was a local executive when he was appointed governor of the province of Pampanga. Our lecturer has been to all branches of the government except the judiciary. But as the Solicitor General, he was regarded as the 16th Justice of the Supreme Court. It is said that the people power and its fruit, the 1987 Constitution, are the great testimonial to Philippine postmodern democracy. This afternoon, we shall go one step further and see whether or not the 1987 Constitution is in reality a Marcos legacy. Thank you, and mabuhay po tayong lahat.
And now to give us the lecture, the 1987 Constitution, a Marcos Legacy, I'd like to call on Attorney Estelito P. Mendoza.
President Pascual, I am privileged to have the UP President here, no less. Dean Concepcion, members of the faculty. Shall I finally say fellow students? Because I remain a student up to now. let me start by saying I have a problem. I have a hearing problem, but I cannot control what I would hear and not hear, except as to my wife. When I know she is going to give me a sermon, I just take off my hearing facilities. The 1987 Constitution, a Marcos legacy. Provocative, intriguing, stimulating, even seductive. But I can assure nothing sexy about what I'm going to say have been said of the subject of the title of my lecture. Allow me, therefore, to immediately relieve you of your anxieties. Never again, President Marcos, that appears to have been the primary, if not the dominant and consuming mission of the Constitutional Commission in drafting the 1987 Constitution. The image of President Marcos seems to have been at all times in the mind of the members of the Commission. Fundamental provisions of the 1973 Constitution, including those derived from the 1935 Constitution, apparently perceived to have been instrumental in the assumption and exercise of the powers of government by President Marcos, have been exorcised from the Constitution. In the process, the historic distribution of power of government among the executive, legislative, and judicial departments have been altered. The relative weight of checks and the consequence balance have been changed. Principally, presidential powers have been emasculated, and although in a lesser category, legislative power as well. The ultimate checking function has been vested in the judiciary. The scope of judicial power has been broadened, overreaching its traditional role as arbiter. The President's power as Commander-in-Chief emasculated. President Marcos issued Proclamation Number 1081, proclaiming a state of martial law in the Philippines on September 21, 1972, by virtue of the powers vested in the President in Section 10(2), Article 7, otherwise known as the Commander-in-Chief Clause of the 1935 Constitution that was still in force. It provided as follows. To expedite, I will assume you know these provisions. I will not read them anymore. Section 11, Article 7 of the 1973 Constitution is a verbatim copy of the same provisions. The powers of the President as Commander-in-Chief were principally the target of emasculation by the 1987 Constitution. This was accomplished in its Section 18, Article 7 as follows. A. The imminent danger phrase was eliminated in the 1987 Constitution. As a consequence, the President may only suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law in cases of invasion or rebellion, unlike both under the 1935 and 1973 Constitutions, where he may suspend the privilege of the writ of habeas corpus or place the Philippines or any part under martial law in case of imminent danger of such contingencies. And B, second, under the 1987 Constitution, the suspension of the privilege of the writ of habeas corpus or the proclamation of martial law can only be for a period not exceeding 60 days, while under the 1935 and 1973 Constitution, no duration is provided. Unlike the 1987 Constitution, the President is required within 48 hours from the proclamation of martial law or suspension of the privilege of the writ of habeas corpus to submit a report in person or in writing to the Congress. The pertinent provision of the 1987 Constitution reads as follows. I will not read it anymore. D. Not only Congress, but the Supreme Court may review the suspension of the privilege of the writ of habeas corpus or the proclamation of martial law, as the 1987 Constitution provides, and I read this provision, Section 18, the Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. You must note, it says, the sufficiency of the factual basis of the proclamation of martial law. So if the proclamation says there is a rebellion, you need to present evidence that there is a rebellion or whatever it is. Next, the consequences of the proclamation of martial law are explicitly limited in the 1987 Constitutions. I will just abbreviate this. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or the legislative assemblies, not authorize the conferment of jurisdiction in military courts, etc. That is because this was what was done when President Marcos proclaimed martial law. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. Frankly, I do not understand it. If there is a charge already, you do not need the suspension anymore. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. Well, that is actually contrary to the purpose of a suspension. Anyway, the above provisions of the 1987 Constitution are detached from reality. They were apparently conceived in a vacuum. When there is an invasion or rebellion, actual and present, we can hardly imagine a Supreme Court holding a trial to determine questions of fact, or a Congress debating and deliberating on the propriety of the proclamation. Should there be an invasion or a rebellion with the incident disorder and chaos, the President as Commander-in-Chief responsible for the preservation of the state, when he sees the need to proclaim martial law or suspend the privilege of the writ of habeas corpus, he will, in my view, proclaim martial law and suspend the privilege of the writ of habeas corpus and simply ignore the explicit provisions of the explicit required restraints provided in the 1987 Constitution. On hindsight, I have been often asked myself whether President Marcos would have declared martial law had the Commander-in-Chief clause been as it now appears in the 1987 Constitution. I was not privy to the issuance of Proclamation number 1081, although some believe that I was or that I had even drafted the proclamation. The belief may have been fueled by the fact that just a few days before the Proclamation 1081, I was at a well-publicized meeting of generals of the military where I was the only civilian. I was as surprised at its issuance as the people generally were. Let me narrate a meeting at Malacanang soon after the issuance of Proclamation number 1081 was announced. This would give a sense of how President Marcos regarded law and of the question I had earlier raised. Soon after the issuance of Proclamation number 1081, several persons, notably Senator Benigno Aquino Jr., were arrested and detained. Petitions for habeas corpus by many of those arrested were filed with the Supreme Court. The Supreme Court promptly directed the respondents, principally then Secretary of Defense Juan Ponce Enrile, to file returns. President Marcos then called a meeting at Malacanang, which included Secretary of Justice Vicente Abad Santos, who was Dean of the College before, and myself, who was Solicitor General, and many others. The issue he raised at the meeting was how government would respond to the petitions for habeas corpus. As an initial and basic issue, he requested us to advise on whether the government would recognize the jurisdiction of the Supreme Court. One view was that the order of the Supreme Court be ignored and to declare the government to have become a revolutionary government. He then asked me directly whether I thought the validity of the proclamation of martial law and the suspension of the privilege of habeas corpus could be justified as constitutional. Without the benefit of a study, I hazard that I possibly could defend it by invoking the political question doctrine, which would constrain the Supreme Court from inquiring into the factual basis of Proclamation number 1081. I had in mind the decisions of the Supreme Court in Barcelona versus Baker and Montenegro versus Castañeda, which barred judicial inquiry into proclamations suspending the privilege of the writ of habeas corpus. Likewise, because of insurgency or subversion intended to overthrow the government, and the more recent case of Lansang versus Garcia, in which case the Supreme Court, while not adhering entirely to the earlier cases of Barcelona versus Baker and Montenegro versus Castañeda, limited judicial inquiry to determining whether in issuing the proclamation the President acted arbitrarily. After discussion, President Marcos decided that the government would recognize the jurisdiction of the Supreme Court, and I would defend the validity of Proclamation number 1081. As an observation in regard the proposal that the government simply declare that it had become a revolutionary government, which would have made my job irrelevant, not just easier. He suggested that if the Constitution would effectively be no longer in force, and this is significant, the military particularly may feel that there were no limitations to the power of government. There would not be any constraints to the authority of the military as administrators of martial law. It is better, he said, he indicated, that the Constitution continue in place and in force, and in which the government would be operating would be under the Constitution. I would like to call your attention, perhaps because President Marcos was a lawyer. I do not know whether because he is an alumnus of the UP College of Law. If the question is whether there was rule of law during his tenure, there is no question at all that there was rule of law if the rule of law means acting in accordance with law. He made sure there was a law which was to be the basis of every action of his, even if he had to make the law himself. But the point is, and what is significant about what President Marcos' assumption of power is that he assumed responsibility for every act he did. He did not hide behind any scheme in utilizing other agencies of government to perform what he did as president, so that every arrest, search, and seizure order issued at the time, and there were thousands of them perhaps, were personally signed by President Marcos. I do not think there is any head of state or head of government who has ever done that. Every presidential commitment order was signed by President Marcos, not by the executive secretary in behalf of the president. The validity of Proclamation 1081 was upheld in Aquino versus Enrile, which was a consolidation of several petitions for habeas corpus filed by persons arrested and detained on September 22 to September 30, 1972. Hearings were held on September 26, 29, and October 6, 1972, at which hearings the petitioners were produced in court. The decision in the case was promulgated on September 17, 1974, nearly 2 years after. I would like to mention to you, which you may consider in light of present practice, that every petition for habeas corpus was heard by the Supreme Court. And on occasions, when the matter before the court was of such complicated nature, the Supreme Court held hearings on the case for several days, and that was my job. That was why, by actual count, I was told that I had appeared in the Supreme Court during those times nearly 1,000 times. I was asking once Senator Joker, who was my classmate, I said, why do you keep on appearing? Talo naman kayo palagi. Hindi, sabi niya, mabuti na rin imapahayag sa buong mundo kung anong nangyayari dito. So, and I think we made a plausible stand. The arguments we submitted were plausible enough to merit the consideration even of international observers. While there was near concurrence of all the members of the Supreme Court on the dismissal of the petition, incidentally, they all agreed that rebellion existed at the time. There is not a single opinion which expresses the decision of the court. Instead, there are 6 separate opinions, and as now printed in this graph, consisting of 468 pages. I think no matter what is being said or has been said of the Supreme Court at the time, it can hold its head high simply if you will read the opinions as printed in this graph. They would not suffer by comparison to any decision rendered by the Supreme Court now or before. What must not be overlooked is that after the issuance of Proclamation number 1081, the arrest and detention of many distinguished personalities in the opposition as well as media, did not provoke or incite widespread protests against the proclamation of martial law. I think that is significant. People accepted it. Conditions became better. Even curfew was welcomed by the people. The economic conditions of the country improved. That is what Prime Minister Birata said recently in an interview published in the Star. I would venture the observation that the people in general were happy about the conditions in the country, which were attributed by many to the proclamation of martial law. For those who would like to wrestle with the question of what influences a court to decide the momentous cases of political significance, the question should be as to what extent did the conditions which prevailed immediately after and for some years after the proclamation of martial law influence the decision, and several decisions later. Of what most relevant is that apparently President Marcos, in proclaiming martial law to address an actual rebellion seeking to overthrow the government, took a very broad view as to what was necessary to quell the rebellion and assure the stability of the nation. What he wanted to do was to establish what he would call a new society, utilizing the powers under martial law, not just to preserve the status quo, but to bring about changes necessary to provide stability and prosperity to the country. There is one characteristic, and perhaps obsession of President Marcos, and it is that he wants to ensure that every act of his is in accordance with law. Utilizing his power to legislate derived from the proclamation of martial law, and that is controversial, and later under the 1973 Constitution, particularly its Amendment number 6, he legislated by the issuance of presidential decrees and letters of instructions. Indeed, the administration of President Marcos is noteworthy for the number of laws denominated as presidential decrees or letters of instruction issued. All in all, during that period, 2,053 presidential decrees and 1,504 letters of instruction were issued. This would include 14 codes. Significantly, the 1987 Constitution provided that these laws shall remain operative. Its Section 3, Article 18 so provided. By virtue of this provision, many, if not most, of the presidential decrees remain effective. All of the presidential decrees, particularly and especially the codes, were prepared by those knowledgeable in that area. For example, the Labor Code was prepared by the Ministry of Labor, then headed by Minister Blas Epople. So you have a situation where decrees or laws were enacted, prepared by technically prepared people, and without the necessary and usual influences of lobby of interested or partisan groups. That is how the laws were then enacted. They had that virtue, and apart from that, they were expeditiously promulgated. Perhaps I may mention to you that now we are talking about the problem in the South China Sea, popularly known as Spratly. If President Marcos did not have that power, and he had the guts and the boldness to do what he felt was necessary, the Philippines would not be talking of any claim there. This claim came about only when Admiral or Cloma, we call him Admiral at the time, discovered, he says discovered, but the point is they were uninhabited at the time, to cover these islands, and he went to President Marcos because the Chinese were already threatening to overcome him. And he said, Mr. President, I am willing to cede all of this to the Republic of the Philippines, provided I retain private ownership. Where Marcos said, no, you cede them, but you do not retain private ownership. So right then he told me, prepare the decree by which we declare these islands as belonging to the Philippines, and we constitute them as a municipality, part of the province of Palawan. That is how it started. Well, just among us, no study, no research, just declare, and without that, there would be no claim at all. So it was my task after that to find historical basis for the claim as well as legal basis. Incidentally, in order to determine whether there were historical foundations, I availed of professors of history of the University of the Philippines. This, shall we say, committee or task force, as they call them now, was headed by Professor Serapin Quezon, who was a member of the history department of the UP, and they produced an excellent work. But the work must continue, and it has continued to, at the present time, so that with the Law Center providing some legal foundations for it, but it is not complete. I am afraid the present administration has stopped working on it. All right, now, judicial power as a checking function in the 1987 Constitution has been expanded. Not only did the 1977 Constitution make a change in the Commander-in-Chief clause to assure that there would not be another Marcos in the presidency, the 1987 Constitution expanded the scope of judicial power to assure that judicial intervention may be more easily triggered. The 1987 Constitution, in its Article 8, defines judicial power as follows. The judicial power shall be vested in the Supreme Court and in such lower courts as may be established by law. That is the same as the previous constitutions. But this second paragraph reads as follows, and this is what is significant. Judicial power includes the duty, and I underscore the word duty, of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable. And this, the following clause is even more significant, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Judicial power under the 1935 Constitution is all the same as what I read, section, the first paragraph, vested in Supreme Court and the lower courts. Under the 1973 Constitution, it was similarly defined. As will be noted, those definitions do not really constitute a definition of judicial power, but only defines upon what body it shall be vested, in the same way that the Constitution identifies upon whom executive power and legislative power are vested. But there is one big difference in the definition of judicial power in the 1987 Constitution introduced in the second paragraph, which I have earlier quoted. Of significance in the above definition of judicial power in the 1987 Constitution is the last clause of the second paragraph, which makes, and I have read it before, determine, etc. Elaborating on the reason for the provision, Commissioner Concepcion, who was Chief Justice of the Supreme Court, when the petitions for habeas corpus were filed after the proclamation of martial law, was issued at a meeting of the Commission stated, in explaining this provision, the next provision is new in our constitutional law. I will read it first and explain. Judicial power, and it is the same what the provision reads, involving rights, etc. Then he says, fellow members of the Commission, this is actually a product of our experience during martial law. As a matter of fact, it has some antecedents in the past. But the role of the judiciary during the deposed regime was marred considerably by the circumstance that in a number of cases against the government, which then had no legal defense at all, the Solicitor General set up the defense of political question and got away with it. Well, I was that one. I set up the defense of political question and got away with it. As a lawyer, that means panalo. But the point I make is this. Those decisions of the Supreme Court, where I raised the political question doctrine, and it is not an extraordinary, unique, or peculiar doctrine. It is established in American jurisprudence, has never been reversed by the Supreme Court. They are there. They are no longer good law because they have been reversed by a constitution. In which case, at the time they were promulgated, they were in accordance with the prevailing constitution at the time. It is not quite correct to say that we had no legal defense. If the court decided to determine the questions of fact, I think we could have proven those facts. It must not be overlooked, however, that the 1987 Constitution, in its Section 5, Article 8, defines the power more appropriately, the jurisdiction of the Supreme Court as follows. And this is significant from a procedural viewpoint. The Supreme Court shall have the following powers. This is the power. The other one defines what that power means. Shall have the following powers. Exercise original jurisdiction over cases affecting ambassadors, etc., and over petitions for certiorari, prohibition, ex mandamus, quo warranto, and habeas corpus. I want to emphasize, it says over cases affecting ambassador, and it says over petitions. That is what is vested in the Supreme Court. Then the next paragraph, review, revise, modify, or affirm on certiorari of course the law or the rules of court may provide final judgment and orders of lower courts in A, B, C, D, E. All of these are prefaced by the word all cases, all cases, all cases, all cases. In other words, what I am saying is that the jurisdiction of the court depends on whether there is a case or whether there is a petition. And that is important. If there is no case, then the court is without jurisdiction. If there is no jurisdiction, then it is even premature and irrelevant to talk of the scope of judicial power. But the problem is that the power or jurisdiction of the Supreme Court, even as it is limited to cases, has been casually taken into account by the Supreme Court. Peculiar to judicial power in the overall scheme of the separation of powers of government among the legislative, the executive, and judicial branches, which may justify the characterization of the judiciary as the weakest, are the following. While both the legislative and executive powers are plenary, within their own sphere, judicial power is limited to those matters within the respective jurisdiction of the courts as defined in the Constitution in regard to the Supreme Court and the lower courts by the laws of their creation. And B, the exercise of judicial power by the courts cannot be on the court's own volition or motu proprio. It needs to be activated or triggered by a case or a petition, and a court may not by itself bring about a case or a petition. But the boundaries or the extent of these limitations are defined by the courts themselves, particularly the Supreme Court. In a real sense, the limits of the exercise of judicial power are self-defined, that is, by the Supreme Court itself, and the court's power to do so and its exercise finds justification, if not inducement, in the Constitution, which provides that judicial power includes the duty, etc. That branch or instrumentality of government could only mean the legislative or executive branches, that is, over which the court has the duty to determine whether they committed any act in grave abuse of discretion. However, but the distinction between jurisdiction and judicial power has been casually regarded, not just blurred, but obfuscated by the Supreme Court. Once there appears to be some plausibility in the initiatory pleading that an instrumentality of the government has performed an act with grave abuse of discretion amounting to lack or excess of jurisdiction, the presence of a case, or more particularly, whether the plaintiff is a real party in interest or in a special civil action, the petitioner is an aggrieved person, or that the respondent is exercising judicial or quasi-judicial functions as required in petitions for certiorari, is hardly given relevance. Indeed, the Supreme Court, even when explicitly conceding the inadequacy of interest or standing of the plaintiff or petitioner, or the procedural impropriety of the petition, nonetheless has given viability to the petition or a case sufficient to trigger the court's exercise of jurisdiction. Thus, in Professor M. Abellana versus et al. Versus Secretary Eduardo Ermita, which questioned the constitutionality of Republic Act No. 95/22, which amended the baseline law of the Philippines Archipelago defined in Act No. 3045. The petitioners, who were law professors of this college, Professor Merlin Magalona and Professor Harry Roque, and their students, among they included among the as petitioners all of their students in international law. Di ata nila binasa yung petition, natalo tuloy sila. Were recognized as having locus standi. Incidentally, their petition was dismissed unanimously by the Supreme Court. In resolving the issue raised by the respondents that the petitioners lacked the locus standi, the Supreme Court said, petitioners themselves undermine their assertion of locus standi. As legislators, there are few legislators who join them in taxpayers because the petition alleges neither infringement of legislative prerogative nor misuse of public funds occasioned by the passage and implementation of the law. Then this is what is significant. Nonetheless, in other words, notwithstanding the inadequacy of the standing, nonetheless, the court said, as citizens with constitutionally sufficient interest in the resolution of the merits of the case, which undoubtedly raises issues of national significance necessitating urgent resolution. Indeed, owing to the peculiar nature of RA 9522, it is understandably difficult to find other litigants presenting a more direct and specific interest to bring the suit, thus satisfying one of the requirements for granting standing. So, and anyway, a most interesting case, that case of Magalona involving the baselines, I can claim credit for the enactment of that law. I worked very hard to do that, and it was vital and necessary insofar as the Philippines is concerned, because without baselines drawn in accordance with the convention of the law of the sea, you cannot measure the breadth of your territorial sea or of your exclusive economic zone. In other words, without that baselines law, there would be no basis for us now saying this is within 200 miles, this is within 12 miles, on the basis of which we are claiming sovereignty over certain areas in the South China Sea. A most interesting case is that of Francisco versus House of Representatives. A consolidation, and you will take note of this, of 18 cases instituted by 103 petitioners, which sought to nullify the impeachment complaint against then Chief Justice Hilario Davide Jr., filed by Representatives Gilberto C. Teodoro Jr. and Felix Pentebella for being allegedly barred under Paragraph 5 of Section 3, Article 11 of the Constitution. I shall not deal with the merits of the case, but I was amicus curiae in that case. So, if you consider the real party in interest, obviously it is Chief Justice Hilario Davide, because he was the one being impeached, and he was the one directly and particularly affected by the resolution of the House of Representatives seeking to impeach him. But he was not a party to the case. Instead, you have a combination of so many, 103 all in all, filing the petition. But the Supreme Court, it said, while rights personal to the Chief Justice may have been injured by the alleged unconstitutional acts of the House of Representatives, none of the petitioners before us asserts a violation of the personal rights of the Chief Justice. On the contrary, they invariably invoke the vindication of their own rights as taxpayers, members of Congress, citizens, individuals, or in a class suit, and members of the bar and of the legal profession, which were supposedly violated by the alleged unconstitutional acts of the House of Representatives. Excuse me. When I was arguing as Solicitor General before the Supreme Court, I could argue hours and hours without sitting down. But I will not say age is catching up with me. I still say I have grown older, but not necessarily old. Baba naman ito. Well, anyway, this is the significant part of the opinion. As taxpayers, members of Congress, citizens, individually or in a class suit, and members of the bar and of the legal profession, which are supposedly violated by the alleged unconstitutional acts of the House of Representatives, they have standing. In a long line of cases, however, concerned citizens, taxpayers, and legislators, when specific requirements have been met, have been given standing by this court. In other words, the case was ruled as viable, the case was considered, and the case was decided. I remember that when we were arguing this case, I was saying, but why is Chief Justice Davide not a party to this case? He is in fact there in the other room listening to us. I said, the real reason, as you will note, is that it would have been extremely embarrassing for the Supreme Court to take jurisdiction and decide that case. They were deciding the case of their own Chief Justice. And so, in order to, I say, put a little camouflage on that, the Chief Justice did not become a party. Instead, 103 petitioners, partly he was a popular Chief Justice, 103 petitioners filed this petition, and the court took cognizance of the case. Several opinions were rendered in that case by members of the court who said it is the better act of prudence for us not to decide this case. But the majority ruled that the court had standing, that the petitioners had standing, and they resolved the case in favor of the Chief Justice. Personally, I think that decision is wrong. Do you know what the consequence of that is? You read about during the time of President Arroyo, when impeachment proceedings were threatened to be filed against her, you have Attorney Lozano being there in Congress, even sleeping there, and so that he will be there earliest at 8 o'clock to file a weak impeachment complaint, which will be dismissed and which will bar another impeachment complaint for 1 year. That is how it worked. But the Congress just accepted that. In my opinion, the 1 year period starts to run only after an impeachment complaint is filed in the Senate. That will bar another impeachment complaint, because that is what the Constitution says. An impeachment complaint, there is no impeachment proceeding which is started until an impeachment complaint is filed by the House of Representatives. A citizen or whoever cannot initiate an impeachment proceeding. Only the House of Representatives, by explicit provision of the Constitution, can initiate an impeachment proceeding. But that is how. So actually now, what is only necessary in order the court will do jurisdiction is to have a good lawyer who can write a pleading which will make it appear that you are a party in interest and that an important issue is before the court. That has expanded the scope of judicial power, because while the courts initially cannot institute or trigger a case, that enables just about anybody to trigger a case. Essentially, the court itself can do so. And I think, I would not say of the 100 petitioners, most of them were induced by Chief Justice Davide, but at the very least they were supported of him. That is why they filed those petitions, 103 of them. A gateway for the exercise of jurisdiction by the courts over acts of the legislative and branches of the government, particularly the agencies or instrumentalities of the government, has been provided by the 1987 Constitution. It will be recalled that in blunting petitions instituted to nullify acts of President Marcos, done by virtue of martial law, powers are vested under the 1935 Constitution, later the 1970 Constitution, the government invoked the political question principle, and that accordingly the Supreme Court should desist from ruling on the merits of the substantive issues. Well, let me just go ahead. Anyway, this whole year, I will leave this behind. So that we will have more time for questions. You can ask any question, but I reserve the right not to answer any question either. In light of all this, it is my view that the judiciary, the Supreme Court particularly, has become the ombudsman of the entire government, even if this should be limited only to acts which constitute grave abuse of discretion amounting to lack or excess of jurisdiction. Although the judiciary or the courts have neither the power of the sword or the purse under the 1987 Constitution, they certainly are not in terms of power the weakest department of the government, but that may be inflicting wounds upon itself, which may in time know on its power. Of course, one cannot say it is the most powerful institution. If you have one Secretary de Lima who will not recognize its decisions, na de Lima sila eh. Now I go to another topic. The strengthening or weakening of the Supreme Court and the judiciary. And I say weakening question mark. Having conferred broader power, indeed having imposed a duty on the judiciary, particularly the Supreme Court, it would be expected that the 1987 Constitution would strengthen the judiciary, ensure a higher degree of independence, free from politics, and its ability and efficiency to discharge the responsibilities under the Constitution. Now, let me talk about its independence and imperviousness from politics. Under the 1935 Constitution, members of the Supreme Court and judges of imperial courts shall be appointed by the President with the consent of the Commission on Appointments. Under the 1973 Constitution, they were appointed simply by the President. The 1987 Constitution introduces a drastic change as follows. The members of the Supreme Court and judges of lower courts shall be appointed by the President from a list of 3 nominees prepared by the Judicial and Bar Council for every vacancy. Such appointment need no confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list. There should be no doubt as to the junking of the method of appointment provided in the 1975 Constitution. The appointing power was vested in the President alone, at that time President Marcos. The comparison should be made between the 1935 and the 1987 Constitutions. Under both Constitutions, the appointments shall be made by the President. However, in the 1935 Constitution, the appointment by the President shall be with the consent of the Commission on Appointments, while under the 1987 Constitution, the President shall appoint from a list of 3 nominees prepared by the Judicial and Bar Council for every vacancy. Such appointments need no confirmation. Now, to resolve this, actually, one need examine the members of the Judicial and Bar Council, because the participants now in the appointment is a Judicial Bar Council and the President. The President appoints only from those nominated by the Judicial and Bar Council. Under the 1935 Constitution, it is by the President, as you will recall, and the Commission appointments. The Commission appointments is composed of an equal number from the House of Representatives and from the Senate, so that we may assume that the Commission appointments is political in nature. Now, the appointments, the Judicial and Bar Council is composed of the Chief Justice, the Secretary of Justice, and a representative of the Congress as ex officio members, a representative of the Integrated Bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. Now, of the members of the Judicial and Bar Council, the President would not have anything to do with their appointments, only insofar as the representatives of Congress. As worded, one is not too sure whether Congress should have two representatives, but as now practiced, a member of the Judicial and Bar Council comes from the Senate and another member comes from the House. Now, the rest are appointed by the President. Of course, the Chief Justice, let us not include him anymore. We can assume he is independent. But of the 5 members who are appointed by the President, that is the Integrated Bar, Professor of Law, etc., are all appointed by the President for a term of 4 years with the consent of the Commission appointments. There is no prohibition against reappointment. And while serving as members of the Judicial and Bar Council, these members have regular offices and receive compensation equal to associate justices of the Supreme Court, of the Court of Appeals. So, it is a position that is certainly coveted, especially by retired justices, because they receive their retirement pay, and then when they serve in the Judicial and Bar Council, they will receive again the pay of a Court of Appeals justice. So naturally, every member of the Judicial Bar Council would like to be reappointed, and the reappointment will have to be made by the President. So if you analyze the membership in the Judicial and Bar Council, apparently non-political, but effectively the power to choose has been vested in the number one politician of the country, that is the President of the Philippines. That is how it works. So that instead of depoliticalizing it, I think what has happened is to make the President practically the one who chooses who the members of the Judiciary shall be. That is why now they say these justices are all appointed, because they were appointed during their time. There is a lot of truth to that, because as I said, the choice of the Judicial and Bar Council is largely the choice of members who are appointed by the President, led by the Secretary of Justice. Well, as it works in practical terms, and I look at things realistically, during the time when the members of the Judiciary were appointed by the President with the consent of the Commission on Appointments, the members of the Commission appointments would have an influence in determining who shall be appointed. It cannot be the choice of the President alone. The President has to compromise with the members of the Commission on Appointments. If he does not, then they simply will not be confirmed. So, it is not possible to say that the members of the Supreme Court at that time will have been simply chosen by the President. There will be members who were there who would owe their appointments to a senator or a congressman. That is how, in reality, that previous system works. That is why while the motivations and intention of the Constitutional Commission have always been clear and certainly laudable, I think that many of these provisions were written out of reality. They did not consider the practical way these provisions would work, so that as they desired to depoliticalize the appointment to the Judiciary, They instead effectively vested the appointments, as I said, in the number one politician of the country, that is the President of the Philippines. But of course, realistically, by whoever they are appointed, theoretically, and I say theoretically, when appointed, the members of the Supreme Court should never identify themselves anymore as appointee of President so-and-so, of appointee of Supreme Court. They simply would be members of the Supreme Court. Now, on the organization of the Supreme Court. Under the 1935 Constitution, the Supreme Court shall be composed of a Chief Justice and 10 Associate Justices, and may sit either in bank or in two divisions, unless otherwise provided by law. However, in the 1973 Constitution, the Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. It may sit in bank or in two divisions of 5 members each. The 1987 Constitution provides that the Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. It may sit in bank or in his discretion in divisions of 3, 5, or 7, does not appear to have been influenced by the experience during the Marcos administration. All cases of consequence were decided during the Marcos administration by the Supreme Court en banc. Rather, the maintenance of the number of justices at 15 and the flexibility of sitting in divisions of 3 or 5 or of 5 or 7 appears to have been motivated by the belief that the more the number or the more the divisions, the more cases the Supreme Court can decide. Whether this assumption has been validated by the experience is not altogether clear. Now, the ultimate question is this. What is the perceived function of the Supreme Court? As its powers became broader and as now organized, has it become more capable of effectively discharging its responsibilities and to expeditiously perform its functions? Drawing from my experience as a lawyer, I look at the function of and responsibility of the Supreme Court in particular, and the judiciary in general, to be the ultimate refuge of any person whose rights explicitly provided in Bill of Rights are violated by the Constitution. That may be the only reason, and it will suffice, unless a Constitution has a Bill of Rights and provides an instrumentality by which the violation of those rights is prevented or nullified, the Constitution would have but little value. The principal function of courts, or the judiciary, as described by the Constitution and perceived by the people, is to settle actual controversies involving rights which are legally demandable and enforceable. To assure the intended functioning of government under the Constitution, it likewise resolves conflicts between departments of the government. But while resolution of such conflicts is vital in a well-ordered society, there are vehicles other than the Supreme Court by which those conflicts may be resolved. However, what I would consider the Supreme Court's primordial function is the enforcement of the Bill of Rights. Even though Lincoln's government of the people, by the people, for the people pictures vividly what a democracy is, enforcement and protection against impairment of individual rights enshrined in a Bill of Rights cannot be by the people. In our scheme of government, this is the Supreme Court's function, whose members are not elected by the people. In an effort to reconcile this with the will of the people, the Supreme Court, through Justice Isagani Cruz, has stated, "There is no question that not even the strongest moral conviction or the most urgent public need, subject only to a few notable exceptions, will excuse the bypassing of an individual's rights. It is no exaggeration to say that a person invoking a right guaranteed under Article 3 of the Constitution is a majority of one, even as against the rest of the nation who would deny him that right. I think this is particularly true in these times when the administration seems to determine whether certain rights should be respected based on surveys of the people. It has become political, but that is precisely what the Bill of Rights is about. Since the Supreme Court has neither the power or the purse nor the power of the sword, and its members are not elected, it must draw its strength from the support of the people. That support can only come from the perception of the people of its independence, its impartiality, and the expeditious performance of its functions. While there are many factors which assure and enhance the support of the people for the Supreme Court, there are to me two principal factors. As I have stated, the Supreme Court must be independent and impartial, thus dispensing justice, and it performs its responsibilities or dispenses justice expeditiously. I consider the second as important as the first. The broader power or duty of the Supreme Court under the 1987 Constitution intended to allow the Supreme Court to deal with what are regarded as political. In explaining the above provision, Commissioner Concepcion, and I have dealt with this before, was explicit that the intention was to prevent the political question principle from being invoked to preclude the Supreme Court from inquiring into or ruling on the legality of acts of the executive and legislative departments. But this may itself erode the perceived independence and impartiality of the Supreme Court. The political ticket is likely to have thorns, and the Supreme Court may be bruised and wounded. I will give you an example. The more recent ones, when the Supreme Court decided a case involving the issue of whether President Estrada had resigned, whether President Estrada had ceased to be president and President Arroyo had become the legitimate president. I think the Supreme Court engaged in a political question. The ultimate decision was that to give justification because it had taken cognizance of the case to make a finding that President Estrada had resigned. The ponente was unfortunately Chief Justice Puno. I do not think anybody believes that President Estrada resigned the way he was ousted from the presidency. So that is what has happened. Well, of course, it was worse. The Chief Justice administered the oath of office to President Arroyo. They say as acting president or president after EDSA 2. I think that is the worst thing the Supreme Court has done. It certainly has involved itself in a political matter. So whatever it decides, its decision is going to be affected by the perception that it has become political. I think it had better stayed out of the problem. That is what the political question is all about. Sometimes the best action, as has been said, for the Supreme Court is an act of desistance rather than, well, the most significant case, if I may digress on this issue, is the case of Abellana versus Executive Secretary. That was during my time. The issue was whether or not the 1973 Constitution had taken effect. I took the position that was a political question. That meant the Supreme Court was going to decide whether the Constitution under which it sits is valid or not, is effective or not. I think there could not have been anything more ridiculous. The vote in that case was 4-4-2. 4 justices ruled that it was ratified in accordance with the Constitution. 4 justices ruled that it was not ratified in accordance with the Constitution. 2 justices ruled that the question was political and therefore voted to dismiss the petitions. And consequently, the ultimate decision was, there being no legal impediment, the 1973 Constitution is effective. They said that was crafted by Justice Fernando. Incidentally, maybe by coincidence, those 2 who voted that the question was political ultimately became Chief Justices, Justice Fred Ruiz Castro and Justice Kerube Macalintal. But that was one of the most difficult, but also the most memorable case I had argued. I think we argued that case for 5 days consecutive, every day, up to 8 or 9 o'clock at night. And I was arrayed against the best legal minds of the country. On this side, myself, and with the help of Assistant Solicitor Generals, among which at the time were Chief Justice Puno. On the other side were the most distinguished practitioners, Senator Lorenzo Tanyada, the old man, Attorney Jose W. Jokno, Senator Salonga, Obito Salonga, Cedri Ordonez, of course, Joker Arroyo, and so many others were all there. And I was the one who argued all those cases, but and you cannot criticize the Supreme Court. We were heard fully and exhaustively. It was also exhausting, but I did not have to sit down the way I'm sitting down now. But the question there, if we had lost the case, what would have happened? Personally, I think President Marcos would just simply have declared the revolutionary government. It would not have undone everything, because by that time his term has expired under the 1935 Constitution. Now, this topic of mine is collateral damage to Congress. And it seems to me the Congress does not even realize it. I will just extemporize on this so I can do it quickly. One of the important aspects of a constitution is the power of the Supreme Court of Judicial Review, how to declare laws unconstitutional. Again, I think the image of President Marcos was before the commission. They assumed Marcos was still the president, so they wanted to be able to undo the acts of the president with facility. But they also assumed that he was exercising legislative power. Under the 1935 Constitution, in order that a law may be declared unconstitutional, it needed 2/3 vote. So 11, it must be 8. Under the 1973 Constitution, where the Supreme Court was composed of 15, a law may be declared unconstitutional by 10 votes. Now, under the 1987 Constitution, that has been drastically changed. Let me read now the provision. Under the 1987 Constitution, such cases shall be decided with the concurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted their own. Now, the 1987 Constitution does not provide for the number of members of the Supreme Court who shall constitute a quorum. There are 15, you must remember. Assuming that at least a majority would be required to constitute a quorum or 8 members, a law or treaty may be declared unconstitutional under the 1987 Constitution with only 5 votes, notwithstanding that the Supreme Court is composed of 15. Should a lesser number actually take part in the deliberations on the issue of constitutionality, a lesser number may declare a law unconstitutional, even less than 5. The enactment of a law, it must be borne in mind, is the essence of legislative power. That is what the legislature is for. And yet, under the 1987 Constitution, a law approved by Congress and the President, on occasions ratified in a plebiscite among those affected, may be undone by the Supreme Court with 5 members or even a lesser number voting that the law is unconstitutional. Right. I will not wait for you to ask me a question on the 16 cities case, the famous case where the Supreme Court is accused of flip-flopping several times. But if there is any villain to that situation, it is the Constitution which brought it about. The first vote in that, I think actually the petition should have been dismissed outright, because the petition sought to nullify a law which allegedly did not comply with the minimum income requirement of 100 million as the code was amended. However, there were resolutions in Congress which provided, and that was reflected in the law, that that minimum requirement of 100 shall not apply to these 60 cities. Anyway, I was not the lawyer when the case started. When the case was originally decided that the laws were unconstitutional, not constitutional, it was by a vote of 6-5. 6-5. In other words, a plurality only of 1 vote. That was when I came into the case. I anticipated. Incidentally, there is one significant fact. There are 15, so 6, 5, 11 only took part. 3 took no part, did not inhibited themselves, whatever reason. But 1, and this is significant, Justice Consuelo Inares Santiago, was simply on leave. They did not wait for her to come and take part, and she voted consistently in favor of the constitutionality. Had she been there, the vote would have been 6-6 and the petition would have been dismissed. All right. That was when I came into the picture. I prepared a very exhaustive motion for reconsideration, but I knew and I had apprehensions that this motion for reconsideration was going to be denied in the usual way. The issues having discussed before and having resolved, the motion for no new issues having been raised, the motion for reconsideration is denied. So I anticipated that. It was really, and the reason I anticipated that was because the 6 became 5, because one of them had meanwhile, the 5 rather had become 4, because one of them had retired, Justice Ruben Reyes. So it was timely for the case to be submitted to a vote again, and because we were lacking 1 vote. So I knew the motion for reconsideration was denied. So those of you who are interested in practice, I will give, if you learn from this experience. Since I knew it was going to be denied, I already prepared a very exhaustive second motion for reconsideration with leave. And I detailed the issues which were raised in my motion for reconsideration, which were not previously dealt with by the court in its decision. So when the court denied my motion for reconsideration, within 24 hours, I did not use the 15-day period, within 24 hours, I filed my motion for leave to file a second motion for reconsideration and my second motion for reconsideration. Well, this is how this, I don't know whether you know, they said I was writing letters again to the Supreme Court. I was writing letters actually to the justices, and it turned out to be a wrong move those who did not take part, I wrote them letters individually, officially, not backdoor, not clandestinely. I said, this is an important case involving constitutionally. Why are you not taking part? Kindly take part, I said. That is what I said. And then the only one who took part was Justice Tinga, and he voted against us. But anyway, it was delayed somewhat. Eventually, when the second motion for reconsideration was voted upon, the vote was 6-6. Tie vote. Tie vote. This is the critical part. And I think not many lawyers will think of what I did. When it was 6-6, I did not file a third motion for reconsideration because that is not allowed. What I filed is a motion to amend the resolution that 6-6 vote does not result in a denial because under the Constitution, the constitutionality of a law must be decided by majority vote. So that is told the process. I said in my motion, my prayer was the second motion must therefore be decided, must be submitted for another vote. What the Supreme Court did was to delay it, and then eventually the second motion for reconsideration was granted by 7-5 vote, and I won at that point. Then it was their turn to file a motion for reconsideration, the other side. You know, litigation is like tennis. In order to win, you have to win 2 consecutive points. Not enough to win 1 point. So they filed a motion. It was their turn to file a motion for reconsideration. When they filed a motion for reconsideration, several justices, there were changes, I do not remember, retirements and so on. You remember, I won. They filed a motion for reconsideration. Then that one I lost by 1 vote. So my turn now to file a motion for reconsideration of that decision. That is a first motion for reconsideration of that decision. Then it was my turn to turn the tables. I won that by 1 vote, 7-6. Then, so it is their turn to file now a motion for reconsideration. They won it again, 7-6. So another motion for reconsideration. They won that because, among others, Justice Sereno, who had just been appointed, voted with them, and she very quickly participated. Anyway, ultimately, I won that. I got 2 consecutive votes, winning each vote by single vote. So that is my point. Why should a constitutionality of a law be either declared unconstitutional or affirmed as constitutional by a single vote? That is not in accordance with the fact that a law is the most vital function of the legislative department and should not be easily set aside. That is the reason why you have that vote in that 16 cities case. There is no magic. Anyway, okay. So that is, the problem is this. The members of Congress do not complain. Do you know that those bills which were sought to be declared unconstitutional were passed by the House of Representatives unanimously, no dissenting vote. They were passed by the Senate unanimously also. Then they were approved in a plebiscite, and you declared them unconstitutional by a single vote. That is what would have been ridiculous. In the first place, the court should not have even given due course to those petitions. But that is how the Constitution is. And the Constitution was amended because they perhaps thought it was still President Marcos and he was still issuing decrees. And so they wanted the Supreme Court to nullify the decrees of Marcos easily, even if Marcos is already there in Ilocos, lying still, although not yet buried. Now, I do not want to criticize and not give some concrete suggestions. Let me give my suggestions. I will not go through the explanations. First, well, I would like to suggest that in considering my suggestions, you note the following. I have never been a judge, much less a member of the Supreme Court. I have, however, been engaged in the practice of law as an advocate and a litigator in inferior courts and perhaps more noticeably before the Supreme Court for nearly 60 years. Well, so you do not have to compute. I am nearly 82 already. So I have started practicing law. It will be my diamond jubilee next year from the time I graduated. Now, my suggestions. I suggest that the Supreme Court sits only in banc and that it be composed of a lesser number of members, perhaps 11 members, including the Chief Justice with a more limited jurisdiction. As it is now, there are not just theoretically, but in actuality, 4 Supreme Courts. The Supreme Court in banc and the Supreme Court of its division, 3 divisions. So the decision of each of these is a decision of the Supreme Court. So there are really 4 divisions. I would also suggest that a Supreme Court be of a more limited jurisdiction. This would enhance, hopefully, assure that the deliberation required and intended by the Constitution takes place before a vote is taken and the cases are decided expeditiously. Well, as a lawyer, and I think if you will consider the most important part of the decision process is that the members of the court deliberate before they vote. Now, what is necessary in order that they could deliberate? They must have before them all the necessary papers, the briefs, the memoranda, the evidence. Only then can you say that the vote is a collegial vote, a vote of the Supreme Court. But very frankly, I do not think this is happening because of simply of the number of cases the Supreme Court has. Now, cases in the Supreme Court take too long. And to me, that is unpardonable. But the problem is, to me, the bigger problem is, while the Supreme Court realizes this, I do not see any perceptible move on the part of the Supreme Court to address this problem. I do not think anything is being done to address this problem. You must take note, for example, in the Webb case, Webb was acquitted eventually, but do you know that he was detained for 15 years? 15 years. And most of those 15 years was while the case was pending in the Supreme Court. Well, members of the faculty of the College of Law, they say they get involved in this, but has anyone made a study as to why that Webb case took that long and why Webb was detained for 15 years without the case having been decided? But that is how the reality, and then the Webb case is not an isolated case. It happens in so many cases, and yet there is no perceptible, as I said, action on the part of the Supreme Court to address this problem. The solution, there must be a solution, even if the solution is drastic and radical. All right, let you ask me what is the possible solution. I am not suggesting that it is the solution, but I can only cite the experience and the practice in the United States Supreme Court. In the United States Supreme Court, they receive about 10,000 petitions for certiorari every year. Just like our Supreme Court, perhaps the Supreme Court also receives a little more, but 10,000. What does the Supreme Court of the United States do? They have a procedure whereby they win out all cases except for about 100 cases, all of which they will hear on arguments. In other words, all cases dismissed, except for about 100. What does that mean? That means the decision of the Circuit Court of Appeals stands. And I think at some point, litigation, as has been said, must end. And in this case, the solution probably is that we must have more faith and trust in the Court of Appeals. If not, then we should remedy the problem. But at some point, the Supreme Court must address the more important cases, and it cannot do so unless it tries to address those 10,000 cases. So in the Supreme Court of the United States, they weed out all the petitions for certiorari, keep about 100 or a little more, and then what is very important to me is that all of those 100 cases, and when I say all, I mean all, are heard in oral arguments by the Supreme Court of the United States. And then, within days after the oral arguments are held, the Supreme Court of the United States meet in conference without the participation of anybody, and they vote on the result. Only after the vote is a decision penned by the ponente who is then designated. That is the situation in the United States. Personally, I envy those situations because in my case, I always hope that my cases will be argued. All of the cases, nearly all of the cases I've won on reconciliation were all argued. Those which were not argued sometimes are lost. Because when a case is argued, then you can be sure all the members of the court would be knowledgeable about the case. First, they would have to prepare for the arguments so that they can ask intelligent questions. Second, whether they like it or not, when the case is argued, they have to listen and then ask questions. So, but the problem here in the Supreme Court of the Philippines, only cases of prominence are heard, like Gloria Maroyo Escras. It is being heard actually this afternoon. Other cases are not heard. Even if the penalty, for example, is life imprisonment, those cases are not heard. So eventually, in my view, in the ultimate, usually it is just the ponente who decides. Now, our Constitution explicitly provides that before a member of the court is designated to write the opinion of the court, there must be a deliberation and a vote, only after a vote. But the practice in the Supreme Court, well known to everybody, and then affirmed by the internal rules, is that when a case is filed, the case is immediately ruffled before to what we call a ponente. Now, euphemistically, they change the name ponente to member in charge, but it's the same. When the decision is eventually rendered, check who the ponente is and the member in charge. Nearly, perhaps 95%, the ponente will be the same as the member in charge. So that is defeated. That is the problem. So to me, I am not blaming the Supreme Court. What to me is necessary is that there must be a solution to this problem, even if we must be satisfied that a decision is finally rendered by the Court of Appeals. Increase the number of the Court of Appeals. That is the problem, and nobody is talking about this. Let me fast track. I think you are probably getting a little tired. There are many, there is an effort on the part of the Supreme Court to expedite the disposition of cases. For example, in the lower courts, now they have introduced a system of mediation. But in my view, those systems only delay the proceedings instead of enhance the proceedings. Unfortunately, I think the rules are being changed without appropriate consultation. Just like the 1987 Constitution, they were not realistic about what they were doing. Perhaps I should conclude already, so so that if you have still the energy, and not my energy, you can ask a few questions. Well, my conclusion, one of the conclusions I said is that the need for the bar and the academy to play a role, I think that is necessary. But, for example, to me, there is a need for changing the rules. The much criticized step that has taken place in this case of President Arroyo is that the court of first instance issued the warrant of arrest very expeditiously. The records were that high, and he issued the warrant within hours. He is supposed to have done that. He is supposed to have personally determined probable cause. I think what can be done, and I intend to do this, to propose it to the Supreme Court, but I have not had the time to write it down, is that when evidence is submitted, when information is submitted together with the evidence of probable cause, the prosecution must be required to list that evidence to identify which evidence proves its particular element of the offense, instead of relying on the judge to look. When I was in the government as Minister of Justice, what I would always tell the fiscal is this is the practice which often occurs. I said, when a complaint is filed, the fiscal tells his secretary, gawin mo na dyan yung subpoena, di man niya binabasa. Then when the counter affidavit is filed, he will say, oh, gawin mo na yung information. Total, bahala na si judge dyan. Oh, wala rin nangyari. Pagdating naman kay judge, sabi sa Estelito, gawin mo na yung warrant of arrest. That is not what the procedure is supposed to be. But I think I will not omit my conclusion, which I prepared. Emblazoned at the facade of the hall here where we are now meeting is Justice Holmes' description of the mission of a law school. I have a little, the quote I have is a little different, but I think it is more accurate. I say the business of a law school is not sufficiently described when you merely say that it is to teach law or to make lawyers. Please note the word lawyers, attorney, yung lawyers. Alam mo kasi sa probinsya kung saan tawag sa akin, attorney lang It is to teach law in the grand manner and to make great lawyers. In acknowledging the role of the UP College of Law in accomplishing this mission, Dean Marvick M.B.F. Leonen in exultation declared, indeed, the past century in Philippine history has seen an abundance of UP Law graduates who have helped shape the country's social and political arena. Malcolm Hall has borne a number of presidents, vice presidents, senators, congressmen, judges, and justices of the Supreme Court, proving the college's commitment to academic excellence and service to the public. I think something is lacking there. He did not mention lawyers. Since I have not held any of the positions mentioned by Dean Leonen, which prove the college's commitment to academic excellence and service to the public, I feel particularly privileged and at the same time humbled by having been asked to deliver the 9th UP Law Centennial Lecture. And I thank Dean Concepcion for that. It was after he became Dean that I was invited to deliver this lecture. I hope it was worth it. But I draw comfort from the fact that as one who has been a lawyer, and I state and emphasize the word lawyer, and practiced law for now nearly 60 years, I count myself as among the multitude of graduates of this eminent college, the attorney or the lawyer who is perhaps the only product of this college whom people who are in trouble come to know and also would proudly have as his epithet the simple word lawyer. So, thank you, UP Law. Happy birthday. And to you all, thank you for your forbearance.